to order the City of Belton Planning Commission meeting Monday, November 2nd, 2020. And I'd like to ask if we could have the roll call, please.
Chairman McPherson.
Present.
Mayor Davis.
Here.
Councilman Trutzel.
Here.
Commissioner McDonough.
Here.
Commissioner Monahan Bass. Commissioner Best.
Here.
Commissioner Christie.
Here.
Commissioner Anderson. And Commissioner Warren.
Here.
Thank you. First item would be the approval of the minutes from our September 21 Planning Commission meeting. Do we have a motion to accept?
Make a motion.
I see a motion. Thank you. Is there a second? Second? Mr. Trutzel? Any corrections or adjustments that need to be made to those minutes? Seeing none. All those in favor of accepting the minutes as presented, say aye.
Aye.
Any opposed? We now go to the public hearing. This is for consideration of text amendments to the Unified Development Code, or UDC, for Chapter 1 definitions, Chapter 28 performance standards, fences, and Chapter 30 signs. And Director?
Thank you, Mr. Chairman. As a follow-up to that introduction, as the staff report says, from time to time, amendments are proposed to the Unified Development Code to advance new regulations and land use techniques, to address conflicts and perhaps revise wording to help with administrative situations that arise throughout the use of the code. The staff report kind of lists 1 through 3 as a summary of the amendments that we're going to be discussing tonight. Just a couple of things. Item number 1, we'd like to create a new definition for a mural as a permitted wall sign, and also create a new definition for abandoned signs, and we'll talk about those in greater detail in just a moment. We'd also like to consider amending Chapter 28 pertaining to fences to allow security fencing in front of the front line of commercial and industrial buildings. And we'll also talk about that in greater detail in a few minutes. And lastly, some amendments to Chapter 30 signs. We want to further list abandoned signs as a prohibited signs, and we'd like to consider eliminating the duration that a political sign can be displayed. And we'll talk about all those things in more detail in just a moment. Those are just a kind of 1 through 3 summary. So to begin, for Chapter 1, the definition sections, presently there's a lengthy definition of signs in our Unified Development Code, and that definition of signs includes paintings. So as such, paintings are signs, and signs are limited to 10% of a wall area. So obviously a mural could not be painted on the side of a building if it's limited to 10% of the wall area. Now, there has been some interest in the community to allow painted murals in the downtown area. So, in working with Patrick Corcoran, our city attorney, drum roll, we have worked up a definition, and that is listed in the staff report. I won't read that, but Patrick has come up with a definition of a mural that would be alphabetically listed in the code. We also would like to add a new definition, a definition for abandoned signs to help with enforcement activities. And we have a proposed definition for abandoned signs shown in the staff report also. Presently, we do have some maintenance requirements in the code pertaining to signs, and says signs shall be maintained. What I'm striving to do here is have some more definitive language that defines what an abandoned sign is. And this points out that it's a sign that depicts or refers to a product or business or service that is no longer at the premises. So I think if we have a specific definition of abandoned signs, it would help us with some enforcement activities and allow a clear interpretation to help us with enforcement in terms of removing some abandoned signs. So that then is the just the two definitions that were proposed. If there's no questions about those definitions, I'll go ahead and continue. Is that okay?
That's fine.
All right.
Any questions for the director?
So moving on to Chapter 28, we're kind of doing this in numerical order from the code. Chapter 28 is the performance standards in the Unified Development Code, and it has a number of criteria, but that's the section that does include specifics for fencing. And we have a proposal to allow security fencing in front of the front line of a building in commercial and industrial districts for employee parking. As the code as it is drafted today states that no portion of a fence may extend closer to the front property line than the front corner of the structure. So with that wording means you could not enclose a parking lot that's in front of a building because the fence would be in front of the front line of the building. What we're doing here is addressing some concerns that were brought forward by two large commercial and industrial users. Transwest Trucking brought up this question. It's been a while, and I don't think they're going to pursue it because they haven't got back to us yet, but we wanted to see if we could address it in this proposed amendment to address our question. And the Quick Trip Distribution Center on the outer road has had several conversations in the last 6 months or so about erecting a fence around the parking lot in front of their building for security purposes. And again, this would be fences that are projecting in front of the front line of the building. What we have in that section of the code is a table, and we prepared an excerpt of the table that's in the staff report. And what we would be doing is just dropping in another criteria for security fences. Now, in that excerpt, I do make a note, security fences, and I say decorative wrought iron. I think what I'd like to propose really is it be decorative metal to allow folks to have a greater choice of materials. I don't want to mandate wrought iron necessarily. That can be kind of expensive, but there are some decorative metal fences that look the same, and I think perhaps they might be more affordable. So I'd like the Planning Commission to consider making that change in the staff report. But those would be limited to 6 feet in height. And as you can see in that box, we are proposing that it's only being in commercial and industrial districts for projects for properties larger than 10 acres. And I thought it was important to put in a minimum lot size or an acreage criteria, because I don't necessarily think it would be desirable to have a smaller commercial building begin to fence in their parking lot or their customer parking in front of a smaller building. So I think we want to have this type of amendment be for larger employers or on larger parcels. So that would be the proposal on the fence tables. I'll go ahead and continue on Chapter 30. Now this is a section of the code where additional standards for signs are called out. And this is where we need to write the regulations for the murals and for the abandoned signs. We also are proposing an amendment to political sign requirements. Political signs can presently in the code be displayed 30 days prior to election, and they have to be removed 7 days after. And based on the advice from the city attorney, we're proposing that those days, the duration of the commencing and removal be removed. And the code and the proposed amendments provide for that. So the first thing we're doing is adding abandoned signs is prohibited. So we're saying that abandoned signs are now prohibited, so that gives us the enforcement mechanism to do that in that Chapter 30. And there's a section under 30-R, maintenance, that really talks about what an abandoned sign is and how it needs to be removed. So some greater specificity on abandoned signs. Continuing on with the mural into Chapter 30, this is the section, again, where we write the requirements for murals, and Patrick Corcoran prepared this section, and limits the proposed murals to the Old Town Belton Overlay District, which is a downtown area, which makes a lot of sense for the purposes of a wall mural where you have some pedestrian traffic and street parking. I think that's where you want to see those mural type displays. And Patrick drafted up some standards for really what is a mural, and those are items 1 through 4 in the staff report. Would there be any questions on the draft wording for murals before I continue on moving on down to the political signs?
Mr. Trussell.
I'm not opposed to murals. My question really it goes to the maintenance of those things. I'm thinking downtown, on the other side of the building, we have, gigantic basketball players or whatever. A period of time, those things are going to start to paint's going to start to peel off. And maybe at some point in time, that building is sold, and that mural is still there. So are we going to require them to paint over that and block it off as a normal building might look, or leave it up there and let it deteriorate further? I'm just, like I said, I'm not opposed to it. I'm just trying to figure out a little bit on the maintenance part of it.
Well, the draft wording, Mr. Trutzel, doesn't, item 4 says murals should be kept in good condition, preserved in the manner which they originally created. So I think there we have the ability to encourage a property owner or a new tenant or a new user to maintain that. There wouldn't be a requirement with a change of use necessarily to paint over it, but I think we have the maintenance requirements addressed.
Okay, that's fine. I did have one question about the fence. Can we talk about that or not?
Sure.
I'm not opposed to the metal fence either, but I'm really thinking about, and Red Bridge on Holmes, I'm sure it's a federal facility there, but they have used the large stones with a very secure steel gate going across there. I'm not sure if that's a possibility there as opposed to using metal fencing. And it would be like it would be a much better looking than a fence would be. Just a question more than anything else.
Yeah, those are pretty much barriers to automobile traffic, sure. Right.
Yeah. So that was just a question, just more of an information more than anything else.
Mr. McDonough.
I have a question about both the statements there. When you say a metal fence, this chain link fence, is that, when you say decorative, does that rule out a chain link fence?
That would be my intent, yes, sir. Yeah, we definitely don't want, yeah,
To me, I think we should say that.
right.
And then on a mural, when it says being advertising, billboards, or graffiti are not encouraged, shouldn't that be allowed instead of encouraged? That's pretty loosey-goosey language to me.
Mr. Corcoran can help me with that one.
Yeah, so there was a Supreme Court case in 2015, Reed v. City of Gilbert, which specifically said that cities cannot regulate signs based on the content of the sign. So for example, a mural, we can't ban advertising murals because to tell if that prohibition is effective, we would have to read the sign unless it's content-based. So instead, the most we can do is to not encourage them.
Well, to me, if we have to allow it, I would say we put a stop to it completely if they can do whatever they want. That's basically what you're saying.
Well, they can't do whatever they want. There are some prohibitions that would be in 2 and 3 about not imitating official traffic things or containing vulgar language.
Advertising, graffiti and stuff, they can do that.
I'm not
If they
sure.
want to.
Yeah, I'm not sure.
We encourage them not to.
Yeah, I'm not sure if graffiti would fall under our definition of mural unless it was, I don't know if anybody's been to the plaza recently. There was somebody did a big graffiti mural. Like that could be considered, but just basic spray painting wouldn't be. But for the purposes here, I think the idea was to allow murals into the area and not be overly restrictive. So that was why that language was proposed.
And I get that, but I also get people not doing what we encourage them to do.
Yes. So there could be some amendments made, potentially require?
To make it stronger, I would want it to be stronger.
Okay, well, I think we can take a look at that.
Mayor.
Okay, on the murals, it says they can't contain vulgar, obscene, offensive material, including offensive material of sexual nature, da-da-da-da-da. What if they're doing art, and some people will interpret that as sexual? I'm saying, are we getting into the constitutional part of this? We're going to have constitutionality arguments?
So if you look at the next three things
Right.
on that section, that is the constitutional test to determine whether or not something is vulgar, obscene, or offensive.
Well, and still,
Those
there's,
next to applying contemporary community standards, because if you don't put that in there, they can still do it. But you need to have those standards laid out.
and I think that's what I'm saying. Are we not going to get into a sticky wicket here?
Well, you're in a sticky wicket with any sign.
Okay, it's 'cause
It's just a
this-
different type of sign.
Well, it's, who's going to be the person that interprets whether this is a legal mural?
We
Well,
would,
the same thing with the fences. Who's going to determine that this is a legal fence?
well, for the mural, we would apply the standards put out by the Supreme Court, which you are adopting here, to determine whether or not it is vulgar, obscene, or offensive.
And there is a permit requirement.
There is a permit requirement, so they still have to come to the city and say, here's what we want to do. They can't just go and start painting the side of their wall. We would then review what was being proposed against the myriad of Supreme Court cases interpreting this, including Potter Stewart's very famous statement, I don't know what obscene is, but I can't define what obscene is, but I know it when I see it. We would look at it against that, just like we would with any sign, in any district, in any medium, and then go from there.
Well, and again, this could be interpreted, some murals, as political in some ways that they do their murals. They may be political to me, but not to you.
Going to that relates back to Commissioner McDonough's question. We cannot regulate the content. So you're talking about a political sign. We can't ban political signs.
I worry more about advertising.
Yeah.
A huge billboard is an advertisement, like extreme tires.
Mr. Trutzel, did you have another question?
My question is, so is it illegal then that before we get a mural put up, we can have a drawing of what this is going to look like finished?
That is exactly what they would have to submit to the city.
Okay, okay,
That's how they would receive their permit to do it.
okay. All right, so at that point in time, it could be nixed?
Yes, if it does not comply with any of the standards in the code about murals or then signs particularly in general, it could be next.
Thank you.
Other questions?
All right, then I'll go ahead and continue then. The last item we have in Chapter 30 pertains to political signs. As I stated earlier, political signs, current regulations can be erected no more than 30 days prior to election and shall be removed 7 days after the election. And Patrick is suggesting that the subsection be removed in its entirety and renumbered with items 1 through 4 as in the staff report. And that really pertains to the time duration.
Yes, and again, just like we discussed Reed v. City of Gilbert, this is specifically happening because of that. So to determine whether or not a political sign is up improperly outside of the 30 or 7 day window, you have to read the sign, which then means you are regulating the content of the sign, which under Reed v. City of Gilbert, cities, municipalities, and other jurisdictions cannot do.
And there's still, we can still have a locational requirement. The signs have to be on private property, and these things get put on public right-of-way, and we can certainly eliminate signs on public right-of-way. So that still remains in the code, and I think that's probably the complaint we get the most of. So that would be the staff summary of the proposed amendments. So I'd be happy to answer any question on any of those items for you. Or Patrick, of course, is available.
Any further questions? Mr. McDonough?
Well, I've got a simple question, is like with the political signs, will the city come and make them take it down within 7 days without it being written down that they have to remove them?
You can't do that anymore, period, after Reed v. City of Gilbert. So there will be a new provisions in the sign code relating to temporary signs in the next 60 to 90 days, prior to most likely the next elections.
It'll be a separate temporary sign
Yes,
code in the future.
yes, instead of regulating signs based on their content, like political signs, real estate signs, like that, you instead regulate them all as temporary signs, and then have construction standards and certain limitations on the number of signs. And then you can also regulate the time of when the sign is placed, but it can't relate back to the message that's conveyed. It has to relate to something else, which,
So we would follow up on the temporary signs like the banners and stuff on
exactly.
some businesses that have them right now.
Yes, and essentially what the way that most cities have done that is through requiring, determining certain special events. So like a election would be a special event, which would let people put a certain number of signs in their yard if they wanted to. You're no longer regulating the content because you don't care what that sign says. You can put up however many signs saying whatever you want on there, or they could be political. But so you're still regulating and still ensuring that aesthetics are met, but not infringing on any constitutional rights.
So you're saying there's a temporary sign, we're gonna address that in the near future and enforce it?
Yes.
And enforce it. Okay.
Commissioner Vest?
Thanks. Who enforces it? Like, whose responsibility is it to send a letter or to,
That'd be code enforcement.
oh, okay,
We have 2 code enforcement officers that do that in zoning enforcement.
okay, thanks.
So as I'm understanding, we don't really have any thing that we can do as far as the time. When it comes to political signs, that is going to be dictated to us by the courts, or it has been. And
As-
so we're just making this in,
Exactly. We are
Line
just
up with what
bringing
they've
this
got.
in line with Reed v. City of Gilbert. There will be more substantive changes coming to your sign code that track with Reed v. Gilbert and allow the city to regulate in a manner that is not content-based.
any further discussion on any of the code recommendations? If not, then thank you. We will go ahead and open, if there is anyone here that would like to speak in favor of or in opposition to any of these changes. If so, if you would come to the podium. Nobody's moving. Seeing none, then we will close the public hearing and ask once more if there are any additional questions, comments from the commission. Mr. Warren.
So you said that the drawings have to be approved. Who does that go to? The city commission or just?
No, just be submitted to the planning and building department. And then obviously, if there's a sensitive issue or something that we have an interpretation about, we get the opinion of the city attorney. We collaborate a lot on those types of things.
Mr. McDonough.
And that brings me to, do we have any teeth to turn something down that we don't encourage?
Yes, specifically under subsections 2 and 3. you
So-
do have teeth to turn things down that do not comply with those provisions. Or in the case somebody does put a sign up or paint a mural and then it comes into disrepair, then under 4, you can have them either repaint it or remove it. And if they don't, then it'd be a violation of the zoning code, which they could be fined and ticketed in municipal court.
Let me say, if somebody wants to paint on the side of their building an advertisement for their product, and they come to the city, even though it doesn't fall under any of these, it's still an advertisement. Can we turn it down, or are we stuck with what they want?
We couldn't turn it down, but the thing that I've
Right.
seen in other cities that have adopted similar codes is instead you work with that property owner that intends to paint that on the side of their building to take it from a very basic advertisement. That's just the one that I dealt with the most was there was an insurance company that wanted to just put like a face and then all this, very basic stuff. Instead, the city worked with him and discussed how to make the advertisement a bit more artistically inclined. And he did that, and it's a pretty decent looking mural that,
But if you get somebody that you can't work with, they decide what they want, they get what they want.
not all the time, there's still enforcement provisions within 2 and 3 that we can work with and try
Yeah.
and use or
But they
discourage.
don't fall under there.
Or
you know.
we can still discourage through other matters, and then, again, you can use your enforcement mechanisms if it ever does get to the point where it's in disrepair, and have them fully remove it at that time.
Okay.
Mr. Trutzel.
How does this fall into so many feet per building for advertising purposes? I'm thinking, now I'm gonna paint whole side of my building, which is 2 stories tall and 150 feet wide. I'm gonna paint my advertisement of my business on this side. But that's way percentage over what we know, way percentage over the size of the sign that we typically approve.
The general portions of the sign code do still apply here, so there could be some restrictions based on that. There could also be a proposed recommendation from the planning commission that we change it to put in a size limitation, if that is what the commission wants.
I mean, generally speaking, the murals that I think I've seen, and I'm sure you folks have seen them too, all have an aesthetic, artistic element to them with a variety of things going on in murals. It's not just Joe's appliances on the side of a building. I think it's a great observation, Mr. Trutzel, but from the murals I've seen, I think people put more care and attention into historic events, artistic elements, and things that that I think we would generally find desirable. So,
Mr. Christie.
I think if Joe wants to put an ad on the side of his building and paint it, then it's his building, so we should probably let it. And I don't think we need to be getting into a point of us dictating to Joe what he should put on the side of his building personally. So, my 2 cents.
Mr. McDonough.
Well, I disagree 100%. It's part of the city. And the reason I'm worried about this is there's a couple people who've been here several times, and, I love the murals downtown. I love the basketball players. I love, Mahomes, what we imagine. But I'm afraid what we imagine and what might happen with two or three people come to the top of my head, what'll be painted on the side of a building with this allowance. I love the idea of downtown painting, murals and stuff, and it's like gorgeous downtown and everything. But, that's part of our job as a city to keep it clean and straight and neat. And I think it could get in trouble with just a couple people. And that worries me.
this is limited to the downtown Belton overlay district?
Okay, just downtown, not North Scott, East
Right.
North Avenue or anything.
Mm-hmm.
Mm-hmm.
Correct. Mhm. Okay.
Okay. 'Cause, so just downtown, not North Scott, East North Avenue or anything. Okay.
'Cause, the kind of place where
That makes a difference to me. I didn't
kind of thing where I
realize that.
think you would expect to see murals, because
Right,
you've got
right.
on-street parking, pedestrian activity, where it kind of fits into, I think, that type of fabric.
Okay.
Any additional questions, comments?
I
sir.
think personally, there are a couple of buildings downtown that could use a mural, personally. Yeah.
If no more discussion, would entertain a motion. Mr. Trutzel.
Move to approve the amendments to the UDC as being discussed here for future purposes, I guess. Future discussion.
Just a recommendation onto the city council, yes. Mhm.
So just as a clarification for anyone listening, what we are doing is just passing this to the city council as a recommendation. So it's not that what we say is going to be accepted. It will go to the city council for their approval. So, okay. RJ, did I see? Okay.
Second.
Okay, we have a second for motion. Any further discussion? Seeing none, can we have the roll call, please?
Commissioner Best,
Aye.
Commissioner McDonough,
Aye.
Commissioner Christie. Mayor Davis,
Aye.
Commissioner Warren. Councilman Trutzel,
Aye.
and Chairman McPherson.
Aye. And motion does carry. Will be presented to the city council then. All right, moving on to our non-public hearings. First item we have is consideration of a final development plan for Traditions Third Plat located east of Emily Lane in the Traditions Planned Unit Development. Director.
Thank you, Mr. Chairman. As you stated, this is an application for a final development plan for Traditions Third Plat. This plan will provide for the third phase of construction of the 4-unit multifamily buildings in the Traditions Planned Unit Development. I thought I would just pause here right now and explain a plan and a plat. We have some new members, and believe me, sometimes the staff even gets confused as we look at these things, and is this a plat or a plan? This application is for a plan, which is for the actual physical development that occurs in this plan development. The plan sets up the building design, the architecture, and the landscaping, and it is the development controls for the buildings that occur. In this particular case, as I stated, this is the third phase of the multifamily buildings, and we obviously want this third phase to look like the first two phases. So that's what this plan does. The plats that we'll discuss after this, the plat, I'm sure you may know this, but I'll just go ahead and state it just to be specific. The plat is a mechanism that creates the lots. And that is a document that's recorded with Cass County that creates the lots. And once those lots are created and platted, then you take your plan and you build your buildings and you implement your plan. So that's just a little bit of background. I guess it kind of goes along with the Planning Commission training that Patrick's going to do here a little later this evening. But to continue with this agenda item, the Traditions Planned Unit Development was approved in 2006, and it sat dormant for a while. Salee Development has acquired that property and done a really great job. They had a revised preliminary plan for the Traditions. It was approved by the City Council in 2018. And as it pertains to this application, the original plan and that 2008 provision provided for multifamily units in this exact area. So here we have the copy of the proposed plan. There are 12 new 4-unit buildings on this 7-acre site. So that's a total density of 48 new units, and it's just about 7 units per acre. And that's generally the same overall density that was allocated with that preliminary plan in 2006. This is the third phase. The second phase is here, and there's a continuation of Emily Lane, the public street, that goes east-west through the site, and the 4-unit buildings are proposed around that new street. There's also a north-south street that will be part of a neighborhood collector at some point in the future. This street will extend north to Cunningham and then extend south to Cambridge with subsequent development in those areas. Now, the proposed development plan included elevations and floor plans for the buildings, and these really are the same design as the buildings in the first 2 phases. The building materials include low-maintenance siding, decorative stone on the front elevations. All of these are 2-bedroom units with 1-car garages. We also had a landscape plan submitted, which depicts the location of street trees and the individual plantings around the buildings. There is also a small guest overflow auxiliary parking lot of about 8 spaces here. And the staff is recommending that there be some supplemental landscaping around that parking lot to do a little bit better job of screening. In the 2 earlier phases of the Traditions townhomes, there is some overflow auxiliary guest parking, so we felt like this was important to provide that element and design in this phase 2. So that's consistent with those. As I stated, Emily Lane will be dedicated with the plat, and there's also 3 areas of open space tracts that were dedicated. There's an open space tract north, an open space tract south, and something to the east, and all those will be platted with the plat and will be maintained by the Homeowners Association. So that then would be a summary of the proposed development plan. And again, I will emphasize that this is the same units as in the first 2 phases. And that development by Salee has been very, very successful. The first phase is all leased out, and the second phase of 100 units is substantially underway. And we'll be pleased to see this 3rd phase commence. Be happy to answer any questions, and the applicant is present this evening.
Okay. You have any questions? Mr. Trutzel?
The parking in front of these units, are there enough parking in tandem for 2 cars or only 1 car?
These are 20-foot front setbacks, so the driveways are 20 feet in length, and they are a 1-car garage wide. So each unit has a garage space and a space in the driveway, which is why the overflow parking we felt like was an important thing to begin to look.
I'm thinking about another one we passed on Markey Road, and that thing is the parking, the out front of the house, you put 1 car out there and it's right to the street. And I just want to make sure we don't make that same mistake again.
Also, the 3-bedroom units, too.
Yeah, so that was my question, really.
Any additional questions for the director or for? Seeing none, we'll entertain a motion.
Motion to approve.
All right, thank you. We do have a motion to approve. Is there a second?
Second.
Thank you. Any further questions?
One,
Comments?
is the overflow parking the same as what we've had in the other ones that have been developed?
It's not quite as large as the other 2, Mayor Davis, but it's, that's limited in terms of space here. It's as many spaces as we could get into that small area.
Okay.
Sorry, did you say that the overflow area is maintained by a homeowners association? Is that correct?
Yes. Mhm.
Any further questions? Comments? If not, may we have the roll call, please?
Commissioner Best?
Aye.
Commissioner McDonough?
Aye.
Commissioner Christie?
Aye.
Mayor Davis?
Aye.
Commissioner Warren? Councilman Trutzel?
Aye.
And Chairman McPherson.
Aye. The motion does carry. Move to point B under our non-public hearings, which is the consideration of the final plat for Traditions' third plat located east of Emily Lane in the Traditions Planned Unit Development. Director?
Mr. Chairman, thank you. This is the final plat for the final plan that we just, Planning Commission just approved. This plat will provide for the third phase of construction of the 4-unit buildings in that plan. I won't go over all the details in the staff report because I think I summarized the important points as we discussed the plan. Discussed the density, the number of units. As far as this plat document goes, as I stated earlier, this is the instrument that creates the lots that's signed by the mayor and the clerk and the chairman, recorded with the Cass County Recorder of Deeds. Once this plat is filed, then permits can be issued to implement the plan design that was just reviewed. This plat dedicates the streets, the public right-of-way. There are easements for public utilities shown on the plat, and the open space is indicated as tracks, and the plat meets all the requirements in terms of surveyor certificates and other related technical items on the plat. So I'd be happy to answer any questions, and the applicant is present.
Okay. Thank you, Director. Do we have any questions for the director or for the applicant? Mr. Warren?
You said you wanted extra landscaping. Has that been addressed, or?
That's a condition in the staff report, and so we would look at that revised landscaping plan when the development is submitted for permit and review.
And that is additional landscaping around, specifically around the
Parking
overflow
lot.
parking? Is
Yeah.
that correct?
Yeah, I just envision, let's go back here if we can. Oops. Yeah, here's the 8-space parking lot. There are some shade trees at each corner. I'm just envisioning some plantings, shrubs or bushes of various types of different densities, just to screen automobile headlights and soften up the asphalt around the edges, yeah. And I think they're going to do that. I haven't heard any feedback from the applicant after I wrote that staff report, so that means they're going to be okay with that.
Okay. Any further questions, comments, motions? We do have a motion and a second to accept and approve. Any further comments? Seeing none, can we have the roll call?
Commissioner Best?
Aye.
Commissioner McDonough? Commissioner Christie? Mayor Davis?
Aye.
Commissioner Warren? Councilman Trutzel?
Aye.
And Commissioner McPherson.
Aye. And that is also passed. Move to point C under our non-public hearings, which is the consideration of the final plat for Tradition's fourth plat located on South Mullen Road, south of Sycamore Drive and east of Traditions Parkway. Director?
Thank you, Mr. Chairman. Okay, we're going to move down the road just a little bit here. We have a final plat for single-family units. This is a final plat for Tradition's fourth plat. This will provide for the construction of additional single-family homes in that planned unit development. As with the prior requests, the original PUD was approved in 2006, amended in 2018, and those documents all envision single-family homes at this location. As a little bit of background, there are 50 single-family lots existing in the Traditions Plan development at this time. They've all been developed in new single-family homes, and I think they're virtually all occupied. This plat will provide for 47 new lots for future construction and adding to the new home inventory in the subdivision. As I stated, there are 47 lots and 4 tracts. The lot sizes range from 6,000 square feet to 10,000 square feet, and all those lots meet the minimum lot sizes that were specified in the 2018 revisions approved by the City Council. I think one of the nice things about the revised plat is there is a nice choice of lot sizes for potential buyers and builders. So some of the smaller 6 and 6,500 square foot lots are going to provide some smaller units and some more affordable housing, and there's also some bigger lots back in here. So I think it'll be a nice mix of sizes of units. The final plat includes all appropriate language for utility and drainage easements. One thing I do want to point out was in 2018 there was a revised trail plan for the Traditions, and there is a trail on that 2018 plan. This is where the community pool is here. And this open space tract is supposed to be a trail that comes along behind these lots and will tie in to this tract W here and this public street. So while not shown on this particular plat, there is a stipulation in the 2018 revision that trail be constructed with this phase and completed prior to the next phase. So that's a condition you'll see in the staff recommendation. And I have discussed this with the design engineer, and they're aware of it. So that, I'd be happy to answer any questions, and the applicant is present.
Thank you, Director. Mr. Mayor.
All these are in the Ray-Pec School District?
Yes, I
All
believe
these,
so.
And my next question was, one of the houses is 12,000 square feet plus,
There's one big 12,000 square foot lot up at the corner, right,
and then there's 10,000 square foot ones
right.
to go along with the others.
Yes, sir.
And the trail that you discussed would be the standard 8-foot asphalt trail, is that correct?
Mhm.
Okay. Any additional questions, comments? Mr. Warren?
Just out of curiosity, do we have like a average cost of home that'll be out there?
Thank you. If you will, make sure that the microphone is on and speak into that as close as you can would be helpful for our recording.
Is that okay? You
That's
hear
great.
that? All right.
Thank you.
Tyler Slee with Slee Development. So I think home prices, and you're asking about home prices, correct? Yeah, in this phase, I think you'll see home prices anywhere from 250,000, maybe up to 350. Obviously, probably the higher home prices will be on some of the larger lots in there, but very similar to what's in the first phase, the first plat, which is a variation. You know, there's houses that are 12, 13, 1,400 square feet, and there's some houses that are 2,000 to 2,500 square feet. So 2-car garage, 3-car garage options. Most of these lots will accommodate 3-car garages. Some of the smaller lots will probably be limited to 2-car, but again, very similar to what you see in the first plat there.
Mr.
Do you
McDonough?
have restricted builders there, or are you just selling lots and building specs as you go?
Yeah, so in our first plat, we ended up with about, I think we had 3 builders that we worked with, and they did a variation. Some would do spec building, some would do spec and build job, if they had a custom client that they were working
So
for.
you're gonna restrict the builders?
Yes, yeah, all the builders will work, directly through us. Plans will have to be approved by us prior to building anything, and had to meet, square foot minimums, had to meet exterior facades, those type of things, yes.
Okay.
Anyone
This
else?
HOA,
Excuse me?
this is an HOA?
Yes, there's an active HOA, yeah, there's a Traditions Homeowners Association that's active. All the single-family residents are a part of that, and then all the multifamily residents are a part of that as well. So, that goes towards maintaining common tracks, the community walking trails that Dave had mentioned that will be going in. There's a community pool, playground, things like that.
Where's the big detention, Dave? Can you show me with your,
It's really not on this plat, Mayor. There's a detention area over here, and then a smaller one down here, and then there's a couple basins to the north behind the multifamily.
okay.
That's area-wide detention that's used for the subdivision.
Okay, any further questions, comments? Is there a motion? Have a motion, second? Thank you. Have a motion and a second to approve. Any additional comments or questions before we vote? Seeing none, may we have the roll call, please?
Commissioner Best?
Aye.
Commissioner McDonough? Commissioner Christie?
Aye.
Mayor Davis?
Aye.
Commissioner Warren? Councilman Trutzel?
Aye.
And Commissioner McPherson?
Aye.
Or Chairman, sorry.
All right, so we have approved. That takes us through our items for non-public hearing. As the director did mention, we do have the city attorney here to help us with some training. So, Director, do you want to, I know you're passing the mouse. That's almost like passing the gavel. It's big. But would you like to introduce our city attorney for us?
Patrick Corcoran, our city attorney, is present for some planning commission training. This is a topic that we've talked about in the past, and we felt like with a great new chairman and some terrific new members, it would be good to kind of take a pause here and just kind of look at the things that Patrick and I and the city manager think are important for the planning commission, for their jurisdiction, and for their review. So Patrick, take it away.
Thank you very much, Dave. Again, my name is Patrick Corcoran. I am the city attorney. I work for a law firm. I work for a law firm that specializes and only represents political subdivisions of the state of Missouri. Thank you, Alexa. About 60 to 70% of my practice is based on land use, whether or not that's advising as a city attorney or general counsel or litigating land use matters. So we unfortunately have a lot of experience in this area. Before I get into the actual presentation, there are 2 things that I want everybody to take from tonight's meeting. One is the role of the Planning Commission. The Planning Commission is a recommending body, except for in 2 very limited circumstances that we'll discuss, that is essentially here to serve as the city council's planning experts. The city council is dealing with matters all the time, approval of contracts, stuff like that, and they don't have the time to, get into the weeds on some of the planning issues. So that's what you all are here to do. You're really here to act as the city of Belton's experts in planning. The second thing is always read the staff report. I know that everybody is really busy and it can be tough, but Dave is a planner that has all the certifications you could ever want. And to be honest, not to toot Dave's horn, but out of all the planners we work with, he's 1A or at worst 1B that we work with. So he really does know everything that he's talking about here. I can't say number one alone because I'm, maybe one of them is watching, so, Dave, you know what I think about you. I tell it to you all the time. But read his staff report. It will hit on the relevant topics, and that becomes an issue later on in this presentation when we talk about administrative decisions or ministerial decisions. Because on those ones, you're limited on what you can consider, what is proper to consider. And so we don't want to go off on improper things, have a decision based on that, which then taints the decision going forward and could lead to some bad consequences if the decision was ever challenged. So getting into it. There we go. All right. So there are 4 entities involved in the zoning process. As I discussed, there's Dave and city staff. What city staff is doing is a whole lot of work behind the scenes before anything ever comes here. They're analyzing the issues, they're drafting staff reports, they're proposing amendments to the code to make things flow easier. But city staff is kind of that first step in the process. There are a lot of things that councils and commissions do not see because city staff shuts it down before it can get to that point. But so, first person, city staff. Second is the planning commission. As I discussed, the planning commission is the city of Belton's experts on planning that are here to make recommendations to the city council. I know you might laugh, but that really is the role here. You are the experts. You are the appointed experts for the city of Belton. But your role is to make recommendations except in 2 narrow circumstances and really develop a record that helps support the decision that you recommend and then the city council's final decision. The next party is the city council. The city council is the final decision maker outside of 2 circumstances, and the city council should review the minutes and the record that was created by the planning commission so that they don't have to do that themselves. So they can read what you guys said, analyze the issues that are in the staff report and in your minutes, and then go from there. The final one, which we're not going to talk about tonight, but it's the Board of Zoning Adjustment. What the Board of Zoning Adjustment does is when there is a rule or regulation that creates a hardship or an undue burden on a property owner, they're there to act as essentially an appeals board where that property owner can say, hey, this regulation, due to the physical characteristics of my land, we can't meet this. Can you please vary from that? All right, so now we're going to get to the type of actions. I talked about 2 narrow circumstances where you're the final decision maker. This is one of them. You did one tonight, and this is the other one. It's the adoption of the comprehensive plan. The comprehensive plan is essentially a guide to the development of the city of Belton. The planning commission is the final entity that approves that. And what the comprehensive plan does is it really it touches on everything. Streets, ground spaces, parks, extent of public utilities, and the general character and kind of how the city is laid out in itself. And then once it is adopted, it sits behind us as a guide for all of our other decisions. It's not a strict thing that we have to always comply with, but it is a guide for how we do things going forward. Again, the general purpose is to guide and accomplish the coordinated development of the city. So kind of what the comp plan will do, and what yours does, is it says, okay, we kind of want this area to be residential. We think this is best commercial. We think that the street should be laid out this way. We think that a school should go there. We should think that institution should go here, X, Y, and Z. And then it sits there in the background as the continuous guide for what we do. And it does come into play later on when we talk about rezonings and zoning decisions. There is a reasonableness standard to those. And if your recommendation or the decision that's made by the city council is based on off the comp plan, that's something really good for me if I ever have to litigate it, because I can say, Your Honor, it's clearly reasonable. It's based on the comp plan. Now we're going to get into our less fun type of things. So we have 2 different categories or buckets that your decisions can fall into. Legislative, and then our quasi-judicial or administrative actions. Your legislative actions are the zoning or rezoning of property. So tonight, you heard proposed text amendments. That is a zoning. So that is a legislative action that the planning commission will recommend the city council take. Then you have your quasi judicial or administrative actions. That includes your special use permits, which are uses that the planning commission and the city council have deemed appropriate for the general area, but aren't quite sure if they'll fit in a particular location. So they have to come in, appear before the planning commission and the city council, and kind of explain how they meet the conditions that you guys think are necessary for that use to occur at a particular area. Then the final one is subdivision plat approvals. You did 2 of those. I have gently called those administrative actions. Courts take an even lower approach to that and call those ministerial actions, which essentially means if somebody comes in for a plat approval and they meet all the sections of your code, you have to say yes. There isn't we might say yes, we might say no. No, you have to say yes. And your guys' plat stuff is in, I think, 3635 lays out all the criteria. I almost touched my computer for some reason. So zoning, this is our zoning, rezoning. You did a zoning tonight, you've done rezonings before, but it's based on the city of Belton's police power. So it's our authority to protect the public health and safety and welfare of the citizens. There are quite a few different criteria laid out in section 89040 of the revised statutes of Missouri. Chapter 89 essentially is the zoning enabling act for the state of Missouri. So that if we're ever talking about state law, most of the time for planning commissions, it's section 89 or chapter 89. You could get some other stuff from some different chapters, but that's the main one. So what are some of the common good considerations that the planning commission needs to look at? Because at the end of the day, that's what the planning commission is here to do. You're here to look out for the common good of the city of Belton and ensure that development occurs in a proper manner. So we're looking at traffic, public safety, density of structures, historic preservation, adequate infrastructure. Those are the first ones, and then they go on. Sustainability of use in the suitability of use in the zoning district, property values, and appropriate land use. These are all kind of the things when you're making a decision that you should be thinking about. You know, if we're talking about rezoning a property and they want to go to an industrial use, but directly next door is a daycare or, you know, a school or something that is a protected use that you guys kind of want to make sure nothing bad happens, then you could kind of start talking about the suitability for that area. And then property values, that's brought in a lot when we go from like commercial to residential. That's not a common thing to think about. Again, I think I've brought this example up like 5 times here recently, but the Quick Trip on 150 and 49, if you know that backs up to a neighborhood, and there was some fighting and there was actually condemnation lawsuits filed for that to be built. But that was one of the issues there is a Quick Trip suitable to back up to residential houses? The answer was yes. That's why it's there. Other factors, use of nearby property, that kind of goes to the suitability situation. Extent to which property value could be diminished under the current zoning. So if somebody comes in for a rezoning and says, hey, I'd like to use this property as commercial, it's currently zoned residential. Commercial property has typically a higher value than residential property. That's something that you could keep in the back of your mind when you're making that decision. And then the relative gain to the public versus the hardship imposed on owner if the zoning is maintained. So again, this is more based on property owner initiated rezonings of property. And these are just some of the considerations. Your code also has an additional number of considerations that are laid out, and I've seen Dave discuss them in his code. Planned districts or planned unit development districts, we categorize these as zoning, legislative actions. Because what you're doing through a PUD or a planned development district is you are saying, yes, these uses mix here, and yes, this flow of buildings mixes here. And when that finally gets to the city council, it's approved by ordinance, which an ordinance is a legislative act. So we typically you'll do a PUD at the same time you're doing a rezoning, because most of the time they're rezoning from R1 to R1 PUD or something similar. Again, rezonings can be initiated by the owner, we've kind of talked about those, the city council, or the planning commission, or city staff even. The text amendments that were proposed tonight come from the city staff due to some difficulties we've seen and some new and emerging things that are occurring that we want to kind of get in front of. There are public hearing requirements. You guys had one tonight. 15 days publish notice. When we're rezoning physical property, then we have to mail notice to the property owners within 185 feet. Tonight, were text amendments. There was no property owners within 185 feet, or if you interpreted it that way, you'd have to mail notice to every single property owner in the city. So for text amendments, it's just 15-day published notice and a public hearing in front of you. For rezoning particular properties, then we have two types of notices. We have protest petitions. Those are signed by 30% of the property owners within 185 feet or within the property. Typically, you don't get 30% or more of the property to be rezoned because, again, most rezonings of particular properties are initiated by the property owners. But sometimes, one of the more famous cases that goes under the second bullet point there is Moore versus City of Parkville. That was when the City of Parkville decided to rezone property, I don't know if anybody's been up there, but on the south side of 64th Street, there's now like a Hy-Vee and a Nick and Jake's and stuff like that. And there were property owners across the street that were residential that didn't want that. They filed a protest petition, so then that meant that the city council had to approve it by a 2/3 majority. So if a rezoning were to occur and 30% of the property owners within 185 feet decided to challenge it, then the city council here in our case would have to be 6 votes to get passed.
Is there a specific number of people?
No. So it could be one.
One person?
It could be one person. Typically, that doesn't come into play because you draw a circle. So typically, one person doesn't own all the property surrounding this property in the middle. And in fact, there's been times where I've seen litigation because of 2 people. There's only 2 property owners. One person signed a protest petition. I would say that we should, if you don't like it, I would suggest we all call our legislature and tell them to change it. Because that's something that I would like to see changed too, to create a minimum number of property owners that have to sign it.
Is that residential or?
It's anything. It's just property owner. So
So if it's like a Kohl's, then it's gotta be the owner of that specific Kohl's or Kohl's in general?
it would have to be filed by Kohl's, the corporate entity, or I don't even know. Kohl's probably owns their property in some sort of separate vehicle from Kohl's, the actual department store. There's probably like Kohl's Development LLC or something like that. Like you see it with McDonald's. McDonald's is McDonald's Development LLC. Legislative actions. Now we're getting to the fun stuff about how we review them. This is why we try and categorize as much stuff as legislative as we can. Legislative actions are presumed valid. So the decisions that you're making when you're doing a legislative action, even if for some reason somebody challenges them, they're presumed valid by the court, and the phraseology that's used is they are presumed valid, and that validity is not lightly set aside. So then that person has to come in, and they have the burden of proof to challenge it, and they have to get over the reasonable and not arbitrary and capricious, so there's no basis for the legislative decision that was made. And even if it is fairly debatable, so say it's, judge is like, this is 25, 75, he's probably right, but you're also kind of right, then it has to fall back to the city's decision, because it's a legislative action. And the key here is there's new evidence at trial. So when we talk about our special use permits and stuff like that, those are what are called on-record appeals. So the record that's developed here at the public hearing and then sort of discussed by the city council, that is the only thing that is looked at by the court. They're not looking at anything else. In a legislative action, we can come in and use different evidence outside of that record. And that also relates to you all, and we'll talk about this a little bit more. But when you're making legislative actions, you can use your own personal knowledge and just leave it at that. Say, I don't really think that works over there. When it's on a non-legislative or administrative action. Instead, you should say something more like, I drove by the property yesterday and I noticed that there are 3 other properties zoned X. I don't think it's appropriate for this property to be zoned that. So you've established why you have that knowledge on the record, not just, oh yeah, personal knowledge, here it is. Now we're getting into our administrative decisions. Special use permits, you'll also see these called conditional use permits. That is an interchangeable distinction. There are 3 types of permitted uses, and Dave can correct me if he thinks that there should be more, but there's permitted by right. That is your single-family home in an R1 district. You can just go in and build it, you don't need anything. There are special use permits, which are permitted uses, but you need to come before the Planning Commission and the City Council to show us how you're gonna meet the conditions that we think make it so that that property can be used for that, in that particular location. And then there's permitted uses subject to conditions. So those are also permitted uses, but you don't have to come in and get a special use permit. You just need to establish to city staff how you meet the conditions that were adopted by the Planning Commission and the City Council. So when we talk about some of the conditions, the most common one you see is hours of operation. So, say somebody were to, the city did not handle them this way, but if you wanted to, say there was a dispensary coming into town and you required a special use permit. You don't, you have those as permitted uses subject to conditions. But one of the main things people typically look at would be, okay, we only want you to operate from 10 to 7. Like, we don't want you open till midnight. So we're gonna list that as one of the conditions in the stuff that we approve, and that acts as an additional land use control on top of that property. So they'll have their base C2 commercial, and then a special use permit will also be layered on there that'll have additional conditions, reasonable conditions. And permits may be limited to a certain period of time. The only time that is not true is for telecommunications towers. We can't limit those special uses or conditional use permits. But most of the time, cities will do anywhere from, I've seen as low as 1 year, which just didn't make sense to me. I don't know why they did it that way, up to about 10 years. So, during that duration, they're fine, but once they get close to that, then Dave or somebody at the city will send them a letter saying, hey, your special use permit is about to, come up. You need to come back in and get another one and show us how you're still meeting these conditions. Again, this is some of the case law on it. I decided to throw that in there because I'm an attorney, so I have to be fancy and include at least one case in my presentation. But generally, your guys' decision needs to be in writing, which it always is because it's done by ordinance, and it needs to include some findings. And that's typically always included, again, in that ordinance. And those findings have to be on the record and based on competent and substantial evidence. So what that means is that the things that you're saying, like your personal knowledge, it can still come in, but in a legislative action, you can just say it. But in a special use permit, you need to lay out how you got that personal knowledge, essentially. So like, I drove by the property, I noticed there are X, Y, and Z other uses over there. I don't think that those are compatible together because I've lived in this area for a long time, and I know when this use is next to this use, property values diminish, and it is a significant hindrance to the neighboring property's development, something along those lines. Our final one is platting a property. You guys did 2 of those tonight. A plat, as Dave said, is simply a way to convey title to property, whether that be the dedication of right-of-way and easements or the developer selling lots. That's all a plat does. Under your guys' code, you have a plat and a final development plan that go hand in hand. The plat is what transfers ownership of the right-of-way, the easements, and lets the developer sell the lots. The final development plan sits on top of that and actually acts as a zoning control. Regulates the size and density of buildings and what they look like and stuff like that. And the final development plan is the second of the 2 things that the Planning Commission has final approval on. Those 2. So it's comp plan and final development plan. Everything else, the Planning Commission is a recommending body up to the City Council. And the other thing to always remember about plats is it's a check the box situation. So if they submit something to you and it complies with all of the things that you have in the UDC, you cannot deny it. It has to be approved because it's really just a ministerial act. And for you all, that's not that big of a deal because, again, the plat doesn't regulate the use of the land. It regulates how the land is sold and whether or not there are adequate public improvements and facilities. There are other controls in place to regulate the use of that property. Again, quasi judicial and administrative actions, it's competent substantial evidence as we discussed. So a lot of the times Dave's staff report would be part of that competent substantial evidence. That's why you should always read it and then look at some of the issues that he's pointing out in there, because those are the relevant issues to build that competent and substantial evidence to support your decision. The evidence is limited to the record, as I said, when it's a special use permit and it goes up to the circuit court, all they're gonna look at is the record that is created here in the city council. That's it. They're not gonna bring in anything else. I'm not gonna be able to submit anything else. It's just that. And then the rationale for the decision in the record, again, relating back to why you're making the decision that you're making. That needs to be stated. And then how you all address the credibility of certain people. So I have some examples. We can roll past that. But so making views of the credibility of evidence. So say there's an expert or somebody that's testifying as to why a special use isn't appropriate for that, but you think it is. So on the record, to make it so that everybody knows that you or the planning commission as a whole did not find that person credible, you'd say, like, I find that hard to believe. That is now on the record that the planning commission or you individually as a commissioner did not give weight to that evidence. And that's up to you. You get to decide what evidence gets what weight when it's in here. There's also, I'm having trouble with this logic. Again, you could, if you want to write these down on a little note card and have them in front of you, you could do that. And then always relate the evidence presented to you back to the approval criteria in Dave's staff memo. Dave, for the special use permits, will always kind of list out the criteria to be considered. So if evidence is presented to you that either goes against or for that criteria, relate it back to that when you're making comments and discussing it. So if one of the things is it has to be suitable for the surrounding land uses, which is kind of the general special use permit standard, state that on the record. Say, I don't think this is suitable for the surrounding land uses based on X evidence, because I drove out there and I know that these 3 uses are around there, or on Dave's staff report, it specifically said these 3 uses, that this special use isn't compatible with these other 3 that are right next to it. Use of personal knowledge, as I've talked about, it's okay when it's at the legislative level. You can kind of just, it's okay. Like, you don't have to talk about how you have that personal knowledge. But if it's on a special use permit, you need to state how you have that personal knowledge and the fact that you have personal knowledge. So again, that's the driving by the property. That's the, I live next door to one of these uses and it doesn't quite work. I know it's not compatible. I was dealing with this all the time, stuff like that. And one of the reasons why we do that is because the main concern of the Planning Commission, since you're just a recommending body, is building a relevant record that can support anything, really. So that's kind of the key here, is when you're asking questions, it brings up the ability of other people to also discuss them. So if we have 5 commissioners talking about kind of the same thing that's a relevant criteria from the zoning code, it gives the opportunity for the questions to be put back and forth to each other and even fleshed out more. But again, the key there is personal knowledge and relevant personal knowledge based on the criteria that are typically in Dave's staff report or in the UDC. Expert versus lay witness testimony. If it were the most frequent that this gets brought up is in telecommunications towers, just because those are always hot button topics. People don't typically love when a 120-foot monopole tower is put right next to their house. I've also seen a significant amount of this sort of thing when it came to wind turbines out in like rural Missouri. It's always a big thing. But so when an expert comes in, that expert's credentials will be either stated on the record, so they become part of the record, or if it's a city expert and I'm here, I'm just going to flat out hand you guys his resume or her resume and say, here's the credentials, this is on the record. And then the court, you all can address how you deal with the credibility. And it can even, a lot of the times, one of the saving graces will be if there is an expert and you find that expert credible, is you state, based on this expert's testimony, I believe X. So now you have not only tied your decision into the general standards, but you've also tied it into an expert that presented evidence. Again, we're talking about here the amount of weight that you give people. So experts, we've kind of discussed this previously. But if you think somebody's making a point that doesn't actually track, question it. Ask why they think that, or do they really think that? Or how is this relevant to the factors that Dave put down in his staff memo that in no way address what you're talking about? One of the common ones, going back to the wind turbines, is birds. That always gets brought up. Like, birds are just gonna die. We're not gonna have any birds. I'll use the actual county where we litigated this. We're not gonna have any birds in DeKalb County anymore. They're all gonna die because of these wind turbines. But there was an expert there who testified and was like, there's no adverse effect to birds. These wind turbines are relatively small when given where all birds can fly. And so when somebody got up to say, all the birds are gonna die, members of the Planning Commission went, do you actually think that? Because I'm finding that kind of hard to believe. And you start pushing back and continue to build that record that supports your decision. This is more something for Dave and me when we deal with it, but when we're doing special use permits and stuff like that, we'll make sure that things are on the record, like ordinances that are relevant, staff memos. I'd give an example. This kind of goes more to the BZA, but for the BZA has to have the relevant ordinance in front of them, because all BZA decisions are based on competent substantial evidence. So if the ordinance isn't in front of them or put into the record, then if it gets appealed, the court can't even look at what the ordinance they were trying to be varied from was. Because it's not on the record, they don't look at anything besides the record. Findings of fact and conclusions of law. This is again more specifically to the BZA. Your code does require findings of fact and conclusions of law, I believe, for rezonings of particular properties. And typically when you guys do special use permits, there are findings that are put into the ordinance that's finally approved by the council and then becomes part of the record. Things not to do. Say that you're voting based on something that is completely irrelevant and not in the code or Dave's staff report. So say, I gotta think of a good example. I should have better ones because I've been in some crazy planning commission hearings before. But say there's a McDonald's that's opening up and they have to come in for a site plan or development plan or maybe even a special use, and you just are like, yeah, I don't think McDonald's hamburgers taste good, so I'm just gonna deny this. I'm a fan of Wendy's instead. That's an irrelevant factor that you don't want on the record, and you don't want to state that that's why you're voting that way. So if you're going to make a statement as to how you're voting, make sure that gets tied back into one of the relevant criteria for, the special use permit or the rezoning or something like that. That kind of ties into the second one, but that also goes to competition, because there are some planning commissions that at times kind of make decisions to limit competition, maybe because they want to support local businesses or maybe they like another business over one. But I've seen ones where it's like, there's case law. It hasn't happened in like 40 years, but there's case law where people are just like, yeah, I don't like McDonald's. I like Wendy's, so no, I'm just going to vote no on that. But you could, instead of saying, I don't like them, so I'm not going to let them come in here, you could say, Yeah, but the adjoining property owners, they have trouble with the lights, and they don't think it's compatible because your parking lot lights are gonna be on 24/7 and there's residential property behind it. So that's a real reason to deny something, but just because you don't like something isn't. Or your own kind of personal opinion about a factor.
You have to give an opinion on why you're voting no or yes?
No, you don't, but if you're going to do it, that's how you do it. All of your voting should still be based on the stuff that's in the record, but you don't have to specifically say, I am voting this way because of X. But there are a lot of times with controversial decisions where planning commission members will want to make a point as to why they're making a decision to clarify for the public. I've seen that quite a few times, and that gets you into trouble, especially if it's not based on a relevant criteria. If you're going to base it on incompatibility of the special use with the neighboring use, that's fine, because that's borderline what the decision's supposed to be based on. Regulating competition, we kind of just talked on that. The grocery stores example was a real hot button in the 90s when Walmart started going everywhere. There were quite a few times where Walmart was denied a rezoning or denied a special use permit because of local competition with grocery stores and stuff like that. Pretty much all of those got overturned, and now those communities have Walmart and they don't have their local grocery store. But that's not a relevant factor, and it's not a good one because we don't regulate competition, we regulate the use of land. Ex parte communications. So one of the things that I'll always suggest you do is if you have a question, call Dave. But then if Dave gives you an answer that answers your question, don't just let that sit. Say that on the record. Be like, yeah, I called Dave and we talked about compatibility of uses and he gave me this great description. So now you have made that part of the record and you can use that to base your decision on. If you don't make that part of the record and it's a special use permit, arguably your decision was not based on the record, which then invalidates the decision. And there's some that's why we have these sort of hearings. This is the use of property, so there is some due process considerations to be given. For legislative actions, though, call Dave all you want. You can always make decisions not on the record, and you can have ex parte communications. It's called lobbying. So that's something that always occurs. So, for example, say you're going to rezone a property and the property owner wants to talk to you. That's fine. If it's a special use permit and the property owner wants to talk to you, say okay, but then come in and sit down and be like, well, on the record, I talked to so-and-so and he told me X, Y, and Z.
Can I ask you a question?
Yeah.
When we have somebody come up here and in the past, they've told us they're gonna do one thing and done another, and they have never followed any rules or anything, can we bring that up as their past performance, basically?
If it's provided for in the code, yes, but instead...
If they break the code?
Instead, what I would suggest, if somebody is not complying with the code or with the special use permit, don't deal with that in the public hearing. Instead, I would ask Dave about enforcement of that, because typically, again, the enforcement regulations that cities have under the Zoning Enabling Act and under their codes are very broad and can become very penal very quick. So if somebody's violating a provision of the zoning code or their special use permit or their final development
Or they get a
plan,
special use permit and don't do what they say they're gonna do?
your code does provide for revocation of a special use permit. And again, we talked about that special use permit acts as an additional layer on top of that property of regulations. So failure to comply with their special use permit is arguably a violation of the UDC, which then subjects them to penalty in municipal court and potentially the city filing an action in Cass County to seek compliance with the special use permit and the conditions that were in there.
Okay.
But I would always, for a special use permit, if there are reasonable conditions that the planning commission wants to require, always make sure that those are included in the final decision and then in the ordinance that the city council approves. Because if they're not in that ordinance and they just said, hey, I pinky promise I'm gonna do this, and there's nothing in writing that requires it, that kind of falls away.
Okay.
And I know I talk really fast, so if you have any questions.
Thank goodness.
Yeah, I'm looking at my phone too.
I'm thinking about a certain business that operates, and they have expanded their business beyond what is normally the stated business according to the business license. So you're saying, what are you saying here that, I don't want to mention any names, but
Well, if it deals with their business license, that's less of a zoning issue. That's a business licensing issue. That would be with the city clerk. Uses of property, you don't need, for the zoning per point, C2 commercial or, R4 residential or all of those have a significant number of uses that can occur underneath them. If they're doing something different than what's on their business license, if they're operating a different separate business, that's less of a land use issue and more of a business license issue unless that additional use is not allowed in that zoning district.
okay.
So if they're in C2 commercial and their primary business is retail sales, and then they got a side gig where they're manufacturing heavy equipment, that would be an issue because they can't manufacture heavy equipment in R2.
Thank you.
Any other questions for Patrick?
And my parting things, if you take home two things from tonight, don't laugh, but you are the city's planning experts that are here to build records and make decisions to support the development of the city of Belton, and always read the staff report. Dave has sent me his staff reports on a couple times, be like, hey, do you have any comments on this? And no, I never really do have a comment on it because Dave's staff report outlined every single thing that I would ever want to be outlined and discussed.
All right, great. A lot of great information and very informative, very helpful for me. I hope a lot of our citizens will take the advantage of watching this on the recording as well, because I think it will be helpful for them if they would take the time to do that. Director, I think we're ready for your report.
Thank you, Mr. Chairman. Maybe just a couple of quick items. In Southview Commerce Center, I want the Planning Commission to be aware that Building 3 is now coming out of the ground. That's the Chewy.com building. They've got some structural steel that's up, and we'll soon start seeing some pour-in-place siding on that building. So once it goes up, it'll go up fast. And also just want to give a mention to the new Casey's. It's on 162nd Street by Cracker Barrel. That project is coming along nicely. It looks pretty nice, and I think it's going to be a great asset over there in Cornerstone Plaza. So keep your eye on that as it comes together. So thank you.
Okay, great. So I guess just kind of a recap from tonight. I was looking back at what we had done at our last meeting, and then tonight another 48 multi-family units and 47 single-family homes that have been recommended for the community. I think, it is just a positive sign for what is happening in the community. Commercially, we've seen a lot, and to see the housing come along that same way. Mr. McDonough.
I got a question for Jeff. When you were asking about the lot size, and you asked about the 10,000 square foot lot size, a little sounds cynical. Is that a small lot size for a city like this?
10,000 square feet?
Mm-hmm.
No, that's above average, yeah.
It
I mean,
is.
our minimum standard in our R1 lot is 8,000 square feet.
Okay.
So.
Okey doke.
But again, a lot of good things happening. So the next scheduled meeting that we have will be on the 4th of January. So I guess, I hate to do this. The right after Halloween, but Merry Christmas, Happy New Year to everyone, because I guess we won't be seeing each other before then. And Happy Thanksgiving, we'll get them all covered. But January 4th is our next scheduled meeting at this time. So we have a motion for adjournment. There's a second. Any opposed that want to stay for a while? If not, we will see you in January. Thank you.
Sure thing.